The panel held that the Americans with Disabilities Act applied to Domino's website and app because the act mandates that places of public accommodation, like Domino's, provide auxiliary aids and services to make visual materials available to individuals who are blind. That's pretty huge. That means that your website must comply with the ADA if your website is how your customer accesses your place of public accommodation. There's those lawyers out there who are already have the paperwork prepared and are already filing lawsuits now that they know that this is endorsed by the Supreme Court.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
There is this case, Domino's Pizza versus Guillermo Robles. It came up from the Ninth Circuit. The appeal was, the reason why Domino's is the plaintiff is because they're the ones who appealed. So it's actually Guillermo Robles versus Domino's Pizza. And this is an application to the United States Supreme Court, which for some reason has displayed itself only as a heading here. This is my printout from their website. And you can see that the petition was denied. Yay! Yay, everybody! The petition was denied. Domino's Pizza lost. Great. What did they lose? The case is actually a really remarkable case that may change the way websites have to accommodate people with disabilities, particularly visual disabilities. So what I thought we would do tonight is look at the Ninth Circuit decision that is being appealed from, that's this part here, from the United States Court of Appeals for the Ninth Circuit, and tell you why I think there is about to be, and in fact already has begun, a flood, a torrent, you might even say, of litigation over the Americans with Disabilities Act and whether it applies to websites, because that's what this says. This court, the Ninth Circuit, then certiorari denied by the Supreme Court is how we say it. When we say that, that means that the Ninth Circuit's law has been let to stand. It has not been challenged by the Supreme Court, who was given an opportunity to rule on it. It's not the same thing as if the Supreme Court unanimously ruled in favor of it, but it's kind of close, because they had the chance to rule on it and they said, nah, this isn't the case. Now, they don't say anything more. They just said petition denied. So we don't know why they denied the petition, and it's not like they've made a ruling. So basically, the Ninth Circuit law is let to stand, and we have to, us attorneys and district courts and appeals courts have to look at the event that the appeal was denied, certiorari to the Supreme Court was denied. Certiorari means like certification to the court. That being denied doesn't tell lawyers and district judges how to interpret that. It is more of a, we have to sort of guess, well, if they liked the law enough to leave it stand, then we should honor that in some way. So this is really going to, in my opinion, this is really going to open the floodgates for litigation over websites that don't accommodate a person with a disability. So let's begin. The panel, remember, this is the Ninth Circuit. This is not the Supreme Court. This is the Ninth Circuit. The panel reversed the district court, who had dismissed the action under Title III of the Americans with Disabilities Act and California's UNRRA Civil Rights Act. The complaint alleged that Domino's Pizza's website and mobile application were not fully accessible to a blind or visually impaired person. The panel held that the Americans with Disabilities Act applied to Domino's website and app because the act mandates that places of public accommodation, like Domino's, provide auxiliary aids and services to make visual materials available to individuals who are blind. Even though customers primarily accessed the website and app away from Domino's physical restaurants. The panel stated that the Americans with Disabilities Act applies to the services of a public accommodation, not services in a place of public accommodation. The panel stated that the website and app connected customers to the goods and services of Domino's physical restaurants. The panel held that imposing liability on Domino's under the ADA would not violate the company's 14th Amendment right to due process. The panel held that the statute was not impermissibly vague, and Domino's had received fair notice that its website and app must comply with the ADA, so the law wasn't a surprise to them. Further, the plaintiff did not seek to impose liability on Domino's for failure to comply with the Web Content Accessibility Guidelines 2.0, a private industry standard for website accessibility. Rather, an order requiring compliance with the WCAG 2.0 was a possible remedy. Finally, the lack of specific regulations not yet promulgated by the DOJ did not eliminate Domino's duty under the law. So this is Judge Owens from the Ninth Circuit Court of Appeals. Plaintiff Guillermo Robles, a blind man, appeals from the district court's dismissal of his complaint alleging violations of the Americans with Disabilities Act at 42 U.S.C. 12,101 and California's UNRRA Civil Rights Act, the UCRA. Robles alleged that defendant Domino's Pizza, Domino's, failed to design, construct, maintain, and operate its website and mobile app to be fully accessible to him. We reverse and remand. So we're reversing the district court's dismissal. So that's saying that the district court should not have dismissed and the case should have gone forward. Robles accesses the internet using screen reading software which vocalizes visual information on websites. Domino's operates a website and app that allow customers to order pizzas and other products for at-home delivery or in-store pickup and receive exclusive discounts. On at least 2 occasions, Robles unsuccessfully attempted to order online a customized pizza from a nearby Domino's. Robles contends that he could not order the pizza because Domino's failed to design its website and app so his software could read them. In September 2016, Robles filed this suit seeking damages and injunctive relief based on Domino's failure to design, construct, maintain, and operate its website and app to be fully accessible and independently usable by Mr. Robles and other blind or visually impaired people. Robles sought a permanent injunction requiring defendant to comply with the Web Content Accessibility Guidelines 2.0. Domino's moved for summary judgment on the grounds that the ADA did not cover Domino's online offerings and that applying the ADA to the website or app violated Domino's due process rights. The district court first held that Title III of the ADA applied to Domino's website and app. The court highlighted the ADA's Auxiliary Aids and Services section, which requires that covered entities provide auxiliary aids and services to ensure that individuals with disabilities are not excluded from accessing the services of a place of public accommodation, in this case, from using the website or app to order goods from Domino's physical restaurants. And there's a note here about what WCAG2 is. They are guidelines for private industry. They are standards for website accessibility developed by technology and accessibility experts. And you can go find out more. Just search for WCAG 2.0. The district court then addressed Domino's argument that applying the ADA to its website violated its due process rights because the Department of Justice had failed to provide helpful guidance despite announcing its intention to do so in 2010. The district court, relying heavily on United States v. AMC Entertainment, concluded that imposing the WCAG standards on Domino's without specifying a particular level of success criteria or without the DOJ offering meaningful guidance flew in the face of due process. The district court held that the DOJ regulations and technical assistance are necessary for the court to determine what obligations a regulated individual or institution must abide by in order to comply with Title III of the Americans with Disabilities Act. And the district court granted Domino's motion to dismiss. The Court of Appeals reviews brand new. This appeal presents 3 questions. First, whether the ADA applies to Domino's website and app. Second, if so, whether that holding raises due process concerns. And third, we're going to skip the primary jurisdiction doctrine over whether the DOJ has failed to provide meaningful guidance on how websites and apps should comply. The ADA, as a whole, is intended to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. Title III of the ADA advances that goal by providing that no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or leases to, or operates a place of public accommodation. We agree with the district court that the ADA applies to... We agree? We agree with the district court that the ADA applies to Domino's website and app. I don't know. I thought they just said that they disagreed with the district court overturning this thing. Whatever. The ADA expressly provides that a place of public accommodation, like Domino's, engages in unlawful discrimination if it fails to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. DOJ regulations require that a public accommodation furnish appropriate auxiliary aids and services where necessary to ensure effective communication with individuals with disabilities. And DOJ defines auxiliary aids and services to include accessible electronic and information technology or other effective methods of making visually delivered materials available to individuals who are blind or have low vision. Therefore, the ADA mandates that places of public accommodation, like Domino's, provide auxiliary aids and services to make visual materials available to individuals who are blind. This requirement applies to Domino's website and app, even though customers predominantly access them away from the physical restaurant. The statute applies to the services of a place of public accommodation, not services in a place of public accommodation. To limit the ADA to discrimination in the provision of services occurring on the premise of a public accommodation would contradict the plain language of the statute. The alleged inaccessibility of Domino's website and app impedes access to the goods and services of its physical pizza franchises, which are places of public accommodation. Customers use the website and app to locate a nearby Domino's restaurant and order pizzas for delivery or pickup. This nexus between Domino's website and app and physical restaurants, which Domino's does not contest, is critical to our analysis. That's important. So it's a nexus between the website and app and the physical restaurants. It says we need not decide whether the ADA covers the websites or apps of a physical place of public accommodation where their inaccessibility does not impede access to the goods and services of a physical location. So they quote Wire v. 20th Century Fox. Our court examined whether an insurance company that administered an allegedly discriminatory employer-provided insurance policy was a covered public place of accommodation. We concluded that it was not, because the ADA only covers actual physical places where goods or services are open to the public and places where the public gets those goods or services. There had to be some connection between the goods or service complained of and the actual physical place. While an insurance company has a physical office, the insurance policy at issue did not concern accessibility or such matters as ramps or elevators so that disabled people can get to the office. And although it was administered by the insurance company, the employer-provided policy was not a good offered by the insurance company's physical office. Unlike the insurance policy in Wire, Domino's website and app facilitate access to the goods and services of a place of public accommodation, Domino's physical restaurants. They are two of the primary and heavily advertised means of ordering Domino's products to be picked up at or delivered from Domino's restaurants. We agree with the district court in this case and the many other district courts that have confronted this issue in similar contexts that the ADA applies to Domino's website and app, which connect customers to the goods and services of Domino's physical restaurants. So I guess the district court dismissed it on other grounds, but did agree that the ADA applies to the website and app, which is not how I read that initially. The second question we address is whether applying the ADA to the website raises due process concerns. And remember, that's the 5th and 14th Amendment that says that you have the right to notice of the law, to a meaningful adjudication of any charges that you violated the law, basically a notice and an opportunity to respond, meaningful opportunity to respond. Despite concluding that the ADA covered Domino's website and app, the district court held that imposing liability on Domino's here would violate its 14th Amendment right to due process. The 14th Amendment incorporated the Fifth Amendment against the states. So the Fifth Amendment applies to the federal government, and the 14th Amendment applies the Fifth Amendment to the states. As a preliminary matter, we hold that Domino's has received fair notice that its website and app must comply with the ADA. An impermissibly vague statute violates due process because it does not give fair notice of conduct that is forbidden or required. So Domino's was arguing that the statute was impermissibly vague. Since it announced its position in '96, DOJ has repeatedly affirmed the application of Title III to websites of public accommodations. Thus, at least since '96, Domino's has been on notice that its online offerings must effectively communicate with its disabled customers and facilitate full and equal enjoyment of Domino's goods and services. However, the heart of Domino's due process argument is not that Domino's lacked fair notice that its website and app must comply. Instead, it argues that imposing liability would violate due process because, 1, Robles seeks to impose liability for failing to comply with the Web Content Accessibility Guidelines 2.0, which are private guidelines, and the DOJ has not issued regulations. Relying heavily on the decision in AMC, that's AMC movie theaters, Domino's argues that this would violate due process because Domino's has not received fair notice of its obligation to comply with the content guidelines. Yet, as explained below, Domino's overstates both the holding of the AMC case and the significance of the content guidelines. AMC concerned movie theater accessibility for wheelchair-bound patrons. Our court reversed an injunction ordering that AMC's stadium-style theaters, many built before 1998, undergo a massive reconfiguration to comply with DOJ's interpretation of an ambiguous accessibility regulation. Our court held that requiring AMC to reconfigure theaters built before DOJ announced its interpretation of the ambiguous regulation would violate due process, so they weren't on notice of what the law was. This case does not present the fair notice concern of AMC, and the district court erred in equating the relevance of the content guidelines with the regulation at issue in AMC. Robles does not seek to impose liability based on their failure to comply with the content guidelines. Rather, Robles merely argues the district court can order compliance with the content guidelines as an equitable remedy if, after discovery, the website and app fail to satisfy the ADA. Remember, they haven't even had discovery yet. This got dismissed on a motion to dismiss, so they haven't even had their basic discovery, and this case is already like 4 years old. Also, unlike AMC, Domino's does not allege that its website or app were created prior to 1996 when the DOJ announced its position that the ADA applies to websites of covered entities. So that's where I think we're going to stop here on that case, because the rest of it's going to be sort of repeating things that we've already seen. They finish by saying, "We express no opinion about whether the Domino's website or app actually comply with the ADA. We leave it to the district court after discovery to decide in the first instance whether Domino's website and app provide the blind with effective communication and full and equal enjoyment of its products and services as the ADA mandates reversed and remanded." We also reverse the dismissal of the UNRWA Civil Rights Act claims. So that's also been remanded there. So that's pretty huge. That means that your website must comply with the ADA if your website is how your customer accesses your place of public accommodation, even if the website isn't the place of public accommodation. You must be ADA compliant. So I think there's going to be a lot of opportunities for lawyers to defend against these cases, because there's going to be a lot of lawyers filing these kinds of cases. Can we find any statistics on how many of these cases are being filed? Because I bet you it's a lot. So a few takeaways from here. It seems like the activity of Americans with Disabilities Act charges under the EEOC. So this is not lawsuits. This is so when you have a dispute with your employer, you often have to exhaust administrative remedies, which means filing your disability complaint first with the Equal Opportunity Commission, EEOC. And so these have just about doubled, and they've certainly more than doubled in value over the last 20 years, going from 40 to 50 million in the first years now to 130 million in the last few years. So I think you're going to see a massive explosion. Here's an article from Attorney at Law magazine, ADA Trolls and Unintended Consequences. Let me just see if there's anything in here. One person filed more than 50 lawsuits themselves. One attorney is going to file 8,000 cases after filing 2,000 cases. The Arizona Attorney General's office moved to dismiss 1,000 cases en masse. So yeah, I think it's the floodgates are already creaking open here, and it's just a matter of time before you see that this has to, that there will have to be further guidelines or further compliance. If it's really that big of a deal, then you're going to see lots of litigation, because there will be lots of lawyers who want to take advantage of that hidden or undiscovered money. So yeah, if you are a host of a website that grants access to goods and services of a place of public accommodation, then you now have to make sure that website complies with basically some kind of content guideline or some kind of the Americans with Disabilities Act does not come out and say, when you hover your mouse over this image, it must do this. That's not how it's worded. So you've probably going to want to look up some intermediary guidelines like the WCAG, the Web Content Accessibility Guidelines 2.0, and follow those, as well as probably contact your attorney. Heck, after reading about this, I might study up and become an expert on, I can't say that word, become competent on Americans with Disabilities Act defense, or advising or consulting, so that I can consult with companies on their websites and explain what they have to do. Let us know what you think about that in the comments below. I think that's bigger than it sounds. I think that it sounds like, ADA lawsuit, certiorari denied. No, that to me, all my lawyer warning bells went off. And if I was a plaintiff's attorney, I would be considering suing people under these circumstances, suing websites under these circumstances where they do not comply with the ADA. So if I'm thinking about it, you can bet there's more powerful attorneys than me thinking about it, because I'm almost nobody in this field. There's lawyers out there who are already have the paperwork prepared and are already filing lawsuits now that they know that this is endorsed by the Supreme Court at this level. The other half of this is that some of these ADA trolls who are not following the spirit of the law are suing for things like one woman's parking lot sign, that handicap parking lot sign was like 3 inches shorter than it was supposed to be, and so she got a lawsuit. And so what's she supposed to do? Are you really gonna spend thousands of dollars on a lawsuit so that you could just raise the sign 3 inches? Like, come on. I mean, somebody was driving the sign into the ground and just went a few inches too far and didn't think about it. So I don't know if that deserves a multi-$1,000 lawsuit. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you to all of you, our viewers and our supporters on patreon.com/ljfrench and sponsors.com/law. Without your support, this channel would not be possible. Currently, our channel is being sponsored by Joshua Davis from TandaPay. Also, thank you to our $50 plus supporters in October: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin, I think it's Hitov. I have to go back and look at your email or your message, Benjamin. I looked at it quickly early in the morning, and I already forgot. So thank you to you, and thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will appear in front of me in the crawl of the videos that go. So thank you for joining me. I'm going to take it out here. We'll see you in the videos that drop. Love you all. Have a good one. I'm Leonard French, your favorite copyright attorney. Bye. Before you have to drop your ball.
Cocoa puppy. Puppies, is that you with a million balls? Is that what I see? Do I see a million balls left here?